with us being here with us tonight for a special meeting. I'll call to order meeting today. The date is Thursday, April 15. It's the time now is 5:38. Ms. City Clerk, can you call the roll?
Councilmember Sanchez,
Here.
Mayor Pro Tem,
Here.
Councilmember Figueroa. You're muted.
Here.
Thank you. Councilmember Sherrod is trying to connect. Councilmember Reynoso.
Here.
Councilmember Calvin.
Here.
Councilmember Alexander.
Here.
Mayor Valdivia is absent. Next, we would proceed with the Pledge of Allegiance.
I'll call on Councilmember Alexander to recite the Pledge of Allegiance for us. Thank you.
Will you please join with me with the Pledge of Allegiance to the flag of our country? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Councilmember Alexander. Ms. City Clerk, do we have any public comments?
We do not have any public comments for tonight.
Okay, so continuing with the agenda, Ms. City Attorney.
Thank you. Mayor and council members, for a presentation for you tonight, we have both an open session and a closed session. This presentation is brought to you primarily at the request of some of you who wanted to get an update and introduction to some of the laws that you have been working with since for those of you that were recently sworn into office. For others, a refresher that have been in office for a little bit longer. What I've tried to do this evening is to prepare, I prepared a PowerPoint for you. We will go over 4 topics as part of our open session meeting. And we will look at the role of the city council, the mayor, talk about your city charter. We'll do a brief review of conducting meetings. We'll talk a little bit about the introduction to conflict of interest rules and your fiduciary responsibilities, including confidentiality requirements. And then we'll do a very, very brief overview of public liability, primarily for the public's benefit, since we will be going into closed session. We listed all of the cases that we have on our books, but I do want to let you and the public know that we are not going to go over each and every one of those cases in detail, primarily because many of those cases are handled by outside counsel. But I know that for those of you that take your responsibility seriously, you wanted to know liability, you wanted to have an idea of the cases and get an idea of how many firms you have working on them. And that's why we listed all of them. I am happy to entertain questions as we go through this process, but it was my intent to try to do about 45 minutes to an hour on the open session and the same in closed session. I'm available to you, for as long as you need me to be, but I am mindful that this is a Thursday evening and that some of you have other obligations. So do you have any questions before I get started?
Just one quick question. And the record can show that I've joined. I got my internet connection back for some reason. Who knows?
Number.
And so if I'm suddenly gone, it's not that I died. It's that my internet. I hope it's that my internet maybe gave up on me. Sonia, I didn't hear all of your introduction, and my concern is everything that we're talking about tonight. When you said roles of the council and what have you, it's all related to the legal, to anything legal. It's not necessarily roles and responsibilities on day-to-day or anything like that. We're just talking about everything related to something that is legal.
I will be staying in my lane, so to speak, as the city attorney, and putting this in the context of the legal requirements and why it's important. And if there is anything that you feel is best handled by the city manager at a subsequent training or presentation, I'd be happy to skip along on that section. So if you're ready, I will share my screen and we can get started here. Okay, so one of the first, let's see if I can. One of the first questions is, why do you need this presentation? And as I mentioned, it's really being presented to you in response to questions and a desire to have some information. We all want a high functioning city. One of the things we have to know is all the laws and how they apply. You, as the mayor and council members, you serve really important roles. You're policymakers. You need to know what the laws are regarding how to meet and how to make these rules. You are the legislature. You make these laws. You have to know how the ordinances work, and you have a lot of financial fiduciary duties to your public. So it is in this mode that we want to make sure that you have the tools to be successful. Professional staff needs your sound guidance. We may not always agree, but we need to be productive. And our productivity increases when we all operate in accordance with your charter, your municipal code, with the law, and therefore your direction is clear. And we know this from experience. For those of you that have been on the council for a long time, for those of you that have served the community, for those of you that have served nonprofits, for those of you that have been activists and have achieved things that you've sought out to achieve, you know that we've got to work in accordance with some of these rules in order to be successful. So, it's my perspective as a city attorney that I do want you to understand the laws. It makes my job easier. It makes the staff's jobs easier when we all agree that these are the laws that we need to be mindful of. But, on a personal note, and I know I've talked to many of you before, I also believe that to achieve our goals together, we have to have good communication and we have to establish our expectations together. And, the more the better it is for all of us. So in that spirit, I prepared these materials for you because I think we have the ability to be a super high functioning city. It starts with the councils. And as a council, I think you can make, a great community happen and you can achieve goals if you understand. So if you have to know the rules if you want to succeed. It's kind of in the realm of a sport or a game. You can't play baseball and win games if you don't know what the rules are. If you can't win at a card game if you don't know what the rules are. So that's what we're going to do this evening. To be successful in your roles, you have to understand really the legal nuts and bolts of the job and how you fit into the overall process. I'm going to brief you on the legal aspects of your roles. As Councilmember Charette alluded to, I think you having an understanding of the current legal issues as well as future legal challenges is essential. And so we'll attempt to do that this evening. So first of all, we want to look at the overall legal authority of the city. And what are the laws that govern you as individuals, govern the city? We start with the California Constitution. It is the document, the Constitution that establishes cities in California. We then look at your city charter. The California Constitution allows the formation of cities. Cities can organize as general law cities or charter cities. You've decided in your community, your voters have decided that you are a charter city. We are also governed by many state laws, many provisions of the government code, the health and safety code, the public resources code, govern your decisions regarding land use, employees, the Brown Act, Public Records Act. I could go on and on and on, but we have to understand these state laws. We also have city ordinances. These are the laws or rules that you've adopted. I'd say 99% of them are codified in your municipal code. We also are subject to federal laws and regulations, Clean Water Act, federal employment laws. And we also are subject to judicial decisions. What have the courts decided? And then finally, we have our own very local city resolutions. We have our own regulations and our own policies. So this is a lot. I mean, as a council member, this is a lot of information for you to digest. What I always say is you don't have to know everything, but you have to know where to find it. And you have to know that I'm available, staff is available to help you access these laws and understand them as you go about and do your work. So I think it's pretty clear that the city of San Bernardino is a charter city. This means the city's organization and your manner of operation is determined by the charter. Your charter is approved directly by the voters, as opposed to being a general law city where the state laws govern your operations. So your charter is a mini constitution for the city. You know, it determines how you're organized, how you operate, provides for your municipal functions and your departments. And the charter also includes some limitations. One thing to think about, a way to think about your charter is like this. We have the United States Constitution, we have the California Constitution, but we wouldn't be able to function with just those two, you know, the constitutions. We have, in addition to the constitutions, the state laws, we have regulatory bodies. And so just as in those, like the state and federal constitution, our charter, our mini constitution is supplemented by your municipal code, is supplemented by your policies. And we see that often, even in the times when we talk about the different roles. So the voters via the charter have declared the city to be a council manager form of government. If you look at Charter Section 200, it specifically says that the municipal government is established and that it will be the council manager form. What does that mean? It really means that this form of government is going to be the system that's going to provide for your political leadership and using a professional manager who you appoint. And this form establishes that in this type of representative type of government, the council will rely upon that trained manager to oversee the delivery of all of your public services, to manage on a day-to-day basis, to hire and fire employees, and to really serve as sort of this liaison between you, the decision makers, and members of your public and also other regional bodies. In this form of government, the council members, you are policymakers, and you're not the administrators in the city. So, you know, why is it important to understand this? Because we call this role clarity. When everybody agrees and we come and understand what the city manager's role is and what the city council's expectations are, that really makes us perform at an optimal level. And this understanding is informed, and here's where it's key. All of this is informed by that city charter, understanding what the law is in your charter, understanding what the municipal code provides for, and understanding the policies that you've seen some of our staff bring to you, like as an example at the last meeting. The role of the city council members is to appoint your city manager. I always tell my clients that the appointment of your city manager should be made on the individual's basis and ability to lead and manage. It is one of the most important decisions you make as a member of the city council. The council members, you establish city policy and goals. If you tell the city manager that you want to see the capital improvement plan implemented, and if you also, you know, approve your budget and put the money there, then that should be implemented, and it should be implemented on the timeline that the city council has established in working collaboratively with the city manager as he or she works with the individual employees. It is also your role to pass laws, land use laws, regulatory laws, and all of these powers are set forth in more specificity in your Charter Section 302. The role of your city manager, as I mentioned, is to manage the day-to-day affairs, also to enforce the laws and ordinances that you have adopted, and to appoint and remove employees, and basically prepare and implement the budget. The role of the manager may include making recommendations to the council based on his or her professional judgment, whether that is to further your development goals in the city, address health and safety issues like code enforcement, or to even propose, revenue generating ideas for you. All the specific powers of the city manager are set forth in Chapter 202 of your municipal code. I have here laying out the role of the mayor. It's important. You can see I have the asterisks up here. I'll tell you why. In a council manager form of government, the mayor is responsible for really soliciting citizen views, helping to interpret them. The mayor presides at the city council meeting. It says in our charter that the mayor serves as the primary spokesperson for the community. And the mayor is supposed to be able to facilitate the communication between the elected officials, the appointed professional staff, as well as your commissioners. The mayor also has a role in assisting the council in setting goals and advocating policy positions that he or she believes are in the best interest of the city. All of the mayor's responsibilities are set forth in Charter Section 303. What's important to note is that in a mayor-council form of government, remember we're talking about a council-manager form of government, but in a mayor-council form of government, which is what you formally had under your previous charter, a mayor is elected separately. Your mayor currently is elected separately, is often full-time and paid, as is the case currently. And here I've underlined with significant administrative and budgetary authority. So when the city council, when the citizens of the city last amended your charter, they kind of left in place some elements of a mayor-council form of government. Although the voters clearly said they wanted a council-manager form of government, it appears to me that they removed the significant administrative and budgetary authority, but they left in your elected full-time mayor with pay. And I think from time to time, we can all admit that some of those things have caused a little bit of friction because there's still expectations there. And I don't point that out to advocate or not. I just point it out as a reality of where we are when I looked at your charter. So you have fiduciary duties. You have a legal duty. This is not just an optimistic, pie in the sky requirement, but you have a legal duty to do good, to do a good job, to do good for your community. When the public chooses an elected official, they vote you into office. They're putting their trust and confidence in you to act in the public's best interest and not in a self-interested way. The concept of a fiduciary duty is that you can help think through the legal and ethical obligations and to really put forth and do good in your public service. And if you take your fiduciary duty seriously, then you cannot act in any manner that's adverse or contrary to the interest of the organization, anything that's contrary to the interest of the city as a whole. And really your fiduciary duty includes, the integrity. Don't breach your duty of confidentiality or duty of care to the city. This is really important because I think when we've had courageous and honest conversations, we have made allegations that we don't feel that people are always putting their fiduciary duty first. And we have concerns about, the breach of confidentiality and also self-dealing and conflicts of interest. So I want to remind you of our duty to keep things confidential in the best interest of the city. A leak of confidential closed session information is a breach of your legal and ethical responsibilities. The Brown Act has a prohibition against you disclosing closed session information. And also your San Bernardino Municipal Code, section 2.58050 in subsection H, says that the mayor and the council shall respect the confidentiality of information concerning the property, personnel, or affairs of the city, and that you shall neither disclose confidential information without approval or legal authorization, nor shall you use the confidential information for personal, financial, or other private interests. And this means any type of interest outside the city, whether those are for-profit or nonprofit reasons. And I just like to stress this again. We want to make sure that you maintain the confidences, because that's how we can best serve the city. I can't go into a closed session and lay out a strategy to save the taxpayers money and how we're going to approach a case if I am in closed session concerned. And at times there have been concerns that information might be shared. So I really encourage you to keep this in particular in mind. The conduct of meetings, we'll move into that topic now. Your conduct of meetings, actually, you do have a municipal code provision that governs the conduct of your meetings. If you haven't seen chapter 2.58, really encourage you to read it. That chapter not only talks about how you will conduct meetings, but it has the closest thing to an ethics code or code of conduct that you have at the city. And so you should be mindful of that. In fact, I'd highly recommend that when you attend city council meetings, you might want to print out a copy of that and keep it handy, keep it next to you. What I wanted to do right now, and I really ask your permission for this, is do a very quick high-level overview of parliamentary procedure, but I do it with a caveat. And that caveat is that the city has not adopted a specific rule like Rosenberg's rules or Robert's rules of order to govern your meetings. So what I've done is I put together a very basic summary of how we can move forward in honoring parliamentary procedure without having yet adopted a particular set of rules. So do you want to go over this section now? Would you guys prefer that we have a subsequent meeting and you choose one of the sets of rules and then we talk about it? I'd maybe just poll you and see what you prefer.
I like the idea of, I appreciate wanting to go over it now, and I'm not opposed to it, but I do like the idea of actually deciding on one of these, such as Robert's rules or something like that in a future meeting.
Okay.
And Sonia, if I may add, for the Boards and Commissions Council did adopt in their bylaws Rosenberg's rules, but did not have it taken that step for the council.
Okay. So what I'm going to do
Sonia,
is,
if I may,
yes,
chime in as well. I agree with my colleague, Mr. Reynoso, that I think the city manager, I think we all realize this, they're planning a day-long kind of roles and responsibilities and just informational. And I think that would be the appropriate time to discuss that. I hear exactly what you're saying, and I'm not opposed to going over it right now either, but I think a robust discussion and adoption of an actual rule is what we really should be talking about and going forward. So I don't know that it's necessary tonight, in my opinion, but I'm willing to sit through it.
no, I think what we should do is just, if you would please accept my plea to you to make that a priority to adopt a set of rules so that we can implement them. And I think it'll really go far towards helping us have more efficient meetings, have more respectful meetings, and to really maintain the decorum. I guess I would say this. I will encourage the mayor and the mayor pro tem to at least follow some basic concepts of, how we conduct our meetings. And so I'm going to go through, rather than going through each of these steps. We're really answering the first question is that, do you have to follow parliamentary procedure? Nothing in the law requires you to do it, but it surely makes those meetings more efficient. And even reduces liability, because when you're conducting public hearings, you follow a process and you get the record right. So I would encourage you to do it. I'm just going to move real quick through this and see if I can get to the point where I just want to go through some simple steps.
Yeah, I might add again, from my length of time on the council, we at one time did have a set of rules that we kept in our desk. We used to have a desk drawer actually at the dais, and we did actually appoint through the council a parliamentarian, And that's gone by the wayside for some reason over the last number of years. And I'm not volunteering my services, but somebody that wants to be the parliamentarian and become expert kind of on it, or at least some semi-expert on it, I would support having a parliamentarian that we can actually turn to and say, we'd like a ruling on this, or we'd like your input on it. So that's something, again, that can be up for discussion.
Okay. And what I'm going to do is I'm just going to go over what I consider to be, I think there's like 8 or 9 basic steps. I'm not going to take a whole bunch of time, but I'm going to encourage that we use this format until we come up with a more formal process. Encourage the chair to always announce the agenda item. I think we have our city clerk do that now. Invite the appropriate person to give the report, and then including taking any public comment if it's a public hearing item. Having the chair ask the council members if they have any questions on the item for clarification after that report is made. And then I'd really encourage that we have the chair invite a motion on the item. The feedback that I've gotten so far, even from members of your public, is they're not following, they're not clear exactly what motion it is that you are voting upon. So I think maybe inviting a motion, and then after having that second on a motion, having the chair or the clerk repeating that motion so that it's really clear. And then after that clarity is given, inviting the discussion by each of the council members. You could even take the additional step of repeating that motion again before the voting actually occurs. After taking the vote, we could even be made clear again to your public announcing the result. I say this over and over again because, again, these professional meetings are for us to conduct the business of the meeting, of the business of the city, but it's also really important that your public understand exactly what it is you're doing and what actions you're taking. So I'm not going to go through all the various motions and how you make amendments and substitutions. I think we should leave that for a time when you decide how you want to proceed. So I'm going to...
Again, if I can weigh in to this, because I'm the old guy here that's operated both in City Hall and at the library and others. We've had a screen where we actually had electronic votes. And of course, I'm kind of interested in getting back to electronic votes because it's kind of, gosh, I say this word reluctantly, it's kind of secret as well. I think that when we push a button and everyone doesn't know exactly how one of us has voted, I think that's good for the council. We may in the past have, as we're doing it now, we go right down the line and you get 4 votes in favor, and somebody that maybe wanted to vote against might feel intimidated to vote against at that point. I don't know that this council's experienced any of those concerns, but it can change the balance, I think, if we're just doing it from 1 to 7. And so I'm saying that because when we get back into a different setting, which I think is coming fairly soon, we may be able to go back to a screen where we push a button, we vote, and then the screen shows up how the vote was taken. So that may be overcome with in a new setting. So I don't know if that's really germane to this conversation or not, but I think the announcement is the announcement of the results. It shows up on a screen so everybody can see it.
Okay. Well, I mean, I'm hopeful, as I hope all of you are, to get back and see real people and get out of this virtual meeting situation that we're all in. And I do recall how that worked before. So, we all know the basic rules of courtesy and decorum, letting one person at a time speak, making sure that you're recognized by the chair. And I encourage this, focusing on the agenda item and not on the personalities, whether those personalities are on the dais or a member of the public. Our chair does have the right to cut off discussions that are disruptive or out of order in accordance with your code. So I'm going to leave you with this. I personally have a preference for Rosenberg's rules. I just think they're much simplified. I think they're more appropriate for a city, but you also have the opportunity to adopt Robert's Rules of Order. And there's some resources here that you can look at before you have that discussion of, what you want to use. So let's jump in real quick to the conflicts of interest. I know many of you have had questions about conflicts of interest. This kind of goes to your fiduciary duties. There are several laws that govern conflicts of interest. The California Political Reform Act. The California Political Reform Act is actually an initiative that was adopted by the voters of California in the 70s. And it is implemented through the Fair Political Practices Commission that adopts regulations. Also Government Code Section 1090. That is a conflict law that applies to the adoption or entering into contracts. And then we'll really quickly go through bias and fair process. So before I get started, do any of you have any specific questions about conflicts? That way I can slow down in an area, or I'll just proceed. Have all of you taken your AB 1234 training? Yeah, okay. So you probably heard this before, but I will tell you, I think you need to hear it again and again and again, and that's why the state legislature has made that AB 1234 training mandatory, because I think every time you hear this, you learn more and more. I will say, however, that just hearing the law is not enough. I have a personal, view that knowing what to do and knowing the right thing doesn't mean much if you don't do the right thing. So we have to be mindful of that. So the Political Reform Act, as I said, it was enacted by initiative. It governs public officials, whether you're elected or appointed. The concept is that you should carry out your duties in an impartial manner, free from bias that's caused by your financial interests. This is really important because the Political Reform Act is focused on financial interest. It is not focused on anything but those financial interests. So we can have conflicts of interest that aren't based purely on our finances. They can be based on our familiar relationships. They can be based on friendships. We could have other types of conflicts, but the Political Reform Act is focused in on these economic types of relationships. The Fair Political Practices Commission is the primary agency. It's an administrative body. It's charged with the responsibility of advising public officials, keeping track of economic interests through those Form 700s that we have to file when you assume office every year thereafter and when you leave office. And it enforces the conflict of interest provisions of the Act through both civil and administrative hearings. If you just remember one thing for today, you don't have to dig into the regulations. You've attended AB 1234 training, you know the Political Reform Act. We could spend an hour, 2, 3 going through all of the regulations and digging deep into them. But here's the basic prohibition. You as a public official shall not participate in making or in any way attempting to use your position to influence a decision, a city decision, a governmental decision, when you know or you have reason to know that one of your financial interests will be implicated in that decision. And I always say this is pretty darn easy. You know if one of your financial interests might be impacted by a decision that you're about to make. So that's the sort of the big picture. The way the Political Reform Act works, people, if you really understand the way that it's formatted, is they're telling you don't let your financial interest impact your decisions. And the way that this is laid out is that you are to file and disclose your personal economic interests. You do that with the Form 700, the Statement of Economic Interest. That document is a public document for the world to see. It is one of the few documents under the Public Records Act which must be made available upon its request. We don't get the 10-day period of time. It's one of the documents that when requested must be produced immediately, must be handy And I know that many cities are posting those on their website, or they're available electronically. They use this disclosure so the public can see, and also requires you to disqualify yourself from these decisions where there is an economic interest at play. So every 2 years, the city of San Bernardino reviews its conflict of interest code. That conflict of interest code identifies not just the elected officials, but appointed officials, staff members, and even consultants. By the type of work that we do, we have to disclose to the public where we might have a particular conflict of interest. As I mentioned, the Form 700 filers are the public officials, designated employees, and also can include consultants. There are also various disclosure categories. You probably just finished completing yours. We look at the disclosure categories based on the type of work that's being done. You can be fined under the government code, and the FPPC will send letters out. On occasion, something happened at net filing, and you'll get warnings from the FPPC saying, where are your documents? I have to file a lot of Form 700s for the various public entities that I work with. And I have seen people fined for turning in their statements late. Also, if you just fail to file your statements, it's a violation of the Political Reform Act. It could cost you several thousands of dollars. And I have seen the FPPC fine and pursue civilly elected officials who are not honest in their disclosure categories. Remember that when you file that, you sign it under penalty of perjury. The third component of this Political Reform Act, so it's identifying the financial interests, disclosing those interests, is the disqualification portion. You cannot participate in making, or otherwise influence decisions that affect your financial interests. I once had a elected official say to me, I'm not going to vote on that project. This was about 8 years ago. I'm not going to vote on that project because I have a financial interest. And 35 minutes later, the community development director was calling me, wanting to know why the council member was in his office trying to influence the outcome of that conditional use permit. So it's not just voting on the dais, it's participating in making it or trying in any way to influence the outcome or decision. So when do you have an actual conflict? You ask yourself if the decision is involved, and you ask yourself if you are in any way participating. Are you lobbying? Are you trying to influence? Are you calling the city manager? So the first thing is a decision involved. And then you have to look at whether one of your economic interests are implicated. And there are 5 types of economic interest. Is there a business entity that can be impacted by your decision? A business entity that you own or have an investment in? Is there a real property interest? Is your real property going to be impacted by the paving of the street? Is a leasehold interest going to be impacted? Is there a source of income to you or your spouse? Is there a source of a gift? Is someone giving you a gift, and are they about to be before you asking for a permit or a license or some type of contract? And if there are any of those things, then you shouldn't vote. With respect to the business entity, there are dollar amounts. It matters whether you're a director or an officer or a partner or an employee, sometimes paid or not. And we don't expect you to know the nitty gritty and to know these rules and to know the regulation section 18700. But we do expect you to know, hey, I have a business entity that may be implicated in the decision. The real property interest, the thresholds are low. So if you lease property or if you own property, these days it's more than a $2,000 interest. And so you're absolutely going to have a conflict if it's impacted. And then in terms of income, it's either direct or indirect income of $500 that's been received or promised within 12 months. So I just use this as an example. If you have a spouse like I do that does different types of work with different types of clients. For every $1,000 that he's paid, $500 in a community property state like California is imputed to me, and it could be a source of income it is a source of income to me and could create a conflict of interest. And the same applies to you as well. Gift interest, this number goes up. I believe it's every 2 years, but you are not allowed, there's a limitation on the value of a gift, also on the donor of gifts within a 12-month period. So you cannot receive a gift that's valued at more than $520, nor can you receive from a single person a series of gifts that amount to more than $520. And any gifts that you do receive that are over $50 or more have to be reported on your Form 700. This is a category, your personal finances. It really, again, affects your assets or liabilities of immediate family owners. The analysis includes whether the decision that you're going to make, whether it's reasonably foreseeable that decision will have an impact on your financial interest. The analysis is actually quite complicated. And so, again, we don't expect you to know. What I always say to the elected officials is just remember the categories. Do I have real property? Do I have a business entity at risk? Do I have income, or do I have a gift, a source of a gift that's implicated in this decision? And so if you do have a conflict, your disclosure is mandatory, as I mentioned. And you have to recuse, and then, when we're meeting in person, you have to leave the room. And the reason for that is when we talked about participating or influencing a decision, the reasoning for leaving the room is there have been determinations that if the council is continuing to discuss an item in which one of your financial interests are implicated, and you're sitting in the front row of council chambers and you're fidgeting in your seat or making, gestures, that could have an impact on the rest of the council, and that's prohibited. And that's the reason why you're asked to leave the room. If you violate the full remedies of 3 times the benefit that you received and $5,000. Also, there are potential criminal sanctions. So we take those very seriously. Okay, so now we're going to get into the second part. We talked about Political Reform Act. Are there any questions about the Political Reform Act and how it operates? One thing I forgot to mention about the Political Reform Act, super important, is I don't make the laws. If I got to make the law, I think I would determine that maybe campaign contributions in certain amounts should be the equivalent of a source of income or a gift. But that's not what the law says. The law says that campaign contributions flat out are not sources of income, and they are flat out not gifts. In my opinion, that creates, a big hole in the system, but that is it. Many members of the public have a difficulty reconciling that, and they don't understand why those contributions wouldn't create conflicts, but they don't, nor does income coming from another public agency. So, for example, I've had situations with clients where a council member may be married to an employee of the county or the school district, and the city may be making decisions that's going to impact the school district in a positive way, maybe even impact the particular school at which the spouse teaches, but the rules say that income from another governmental entity does not qualify under the definition, and therefore that spouse can participate. So that's sometimes confusing members of the public as well. There's this little thing called the Government Code, it's Section 1090. It's a big deal because violating it is a felony. The interesting part is, though, it only applies when you're entering into a contract, not when you're permitting a project, not when you're approving a license agreement, nothing like that. It's when you're entering into a contract. If you violate Section 1090, it actually voids the contracts. And as I mentioned, there are significant penalties. It applies even if you're renewing the contract or extending it, or there's some type of grant of funds under that contract. And the financial interests are more broadly defined. In the context of 1090, there is a case that has defined campaign contributions to be a financial interest in the making when there was a contract involved. Again, that's different from the California Political Reform Act. So the making of the contract includes many steps in the making of the contract. It's not just sitting at the dais and approving it. It's whether you're negotiating it, whether you're discussing that contract, if you're planning to enter into that contract, it could create a 1090 violation. By the way, when a council member has a government code section 1090 conflict, unlike the Political Reform Act, where you can say, I have an economic interest, I'm going to step away, recuse myself, with 1090, you cannot recuse yourself. If you have a financial interest in a contract, suppose there's a vendor out there that the city wants to enter into a contract with, and suppose your spouse is a partner in that firm, the entire council is prohibited from entering into that contract. And if you were to enter into it, it's void and the monies are recoverable. So there have been situations I've seen, it's very, very rare, but I have seen situations where council members have resigned because there's a really, really important contract or in the old days under redevelopment, a deal that the city wanted to do, and a council member's presence made it such that they had a 1090 violation. A really important thing to keep in mind is that 1090 applies to outside consultants, particularly these consultants who are considered employees under the law, whether those employees are like a contract city attorney like myself, or someone in your planning department or your engineering department. And the Fair Political Practices Commission, FPPC, has issued some pretty broad letters that implicate these consultants. So you cannot have consultants on board, say, for example, in your engineering department, who are helping the city put together engineering plans, helping them to plan for the big park renovation, and then turn around and also bid on the actual contract to construct the improvements. That would be a 1090 violation. So ramifications are pretty serious. It's a felony, and it's a lifetime bar to serving a public office. So pretty significant. Also, from a civil standpoint, they void a 1090 violation, voids the contract and makes it unenforceable. If there is an illegal 1090 situation, the contractor could lose the entire value of the contract. So this is the part of the disgorgement of all the money. It's just as important for contractors to understand that they could have potential problems as well. And then there's civil and administrative fines. In terms of fair process, there are two things to keep in mind. There's a thing called, violation of due process, and there's also common law bias. So we talked about conflicts of interest, the Political Reform Act, Government Code Section 1090, and common law bias. Common law bias is this thing that basically says, look, you as a public officer should be exercising your duties and your powers with a focus on the benefit to the public and not to yourself. You should not in any way be tempted by any of your personal or financial interests. And when you're so biased, whether that's because, you're so passionate about something that you cannot keep an open mind, you shouldn't be participating. Now, the fair process and due process requirements apply when you are sitting in this quasi-judicial role, like as a judge. When you're making a decision, for example, on a conditional use permit, that is not legislative. Legislative is when you are deciding to amend a zoning code or to adopt a policy. But when you're looking at certain types of things like a conditional use permit, you're actually applying the law. You're taking the rules of the municipal code and you're looking at the facts and you're applying the law and you're coming up with a determination. You're kind of sitting there like a judge. And when you do that, you must give the applicant their due process. There are lots of cases that are starting to develop in this area in two ways. One, when you're having a public hearing and it's a quasi-judicial decision, you need to sit, you need to pay attention, and you need, if you're going to step away or you're not really truly paying attention to the item before you, you need to just admit that and step away from the dais. There have been some cases that say you would violate a person's due process if you're not giving them your full attention in these types of decisions. Also, with respect to the quasi-judicial decisions, if you are biased, then you are violating their rules. I'm actually litigating a case right now where someone has made a fair process claim, and it has cost a city a lot of money. And the fair process claim was actually based on one of the elected officials having a friend who was the consultant on the project. But it wasn't just a friend like in a networking sense, like we all know people. The friend had a 25-year relationship with the elected official and had been known to work together on many, many different projects.
Does this apply to city staff as well, like department heads, which you just said right there?
If a department head has that type of relationship, it could apply. If it's such that the relationship is so close that the department head or the elected official cannot objectively be fair, then it is possible in this quasi-judicial setting that they could violate someone's due process rights.
How do you prove that? How do you prove friendship?
Well, I'd like to believe that people would step away from a decision and do the right thing. How do you prove it? That's why I've been in litigation in this case we're working on for 18 months, and there's been lots of discovery. And sadly, for the people involved, the attorney who brought the claim has been ruthless about digging into their past and digging into their relationship. So that's what is at stake if you decide not to step away. I would say in this case, the personal privacy of the staff members and the elected official, it's just been really embarrassing for everyone around it. So, my advice is don't go there. Stay away from it. Even if you think you can be objective, but you think other people, it's perception. Sometimes people say perception is reality. We got to do the right thing. If we think the public's going to perceive a problem, I think we should do the right thing and step away from it. My personal view. So, okay, we talked about that. If you can't be fair, please don't participate. Please, try to avoid statements before the close of a public hearing. Make decisions based on the evidence that's in the record and not how you feel. Avoid the appearance of bias by talking with people before a hearing or, being seen talking with people before the hearing. Pay attention, as I mentioned. And above all, at the end of the day, you're going to be judged by your fairness and integrity in these types of decisions. And you put yourself at risk when you're not. So I am now going to be headed into the municipal liability section. But before we go there, I'm going to pause again and see if any of you have questions. Okay. We have lots of training materials. If any of you really want to dig into this information, I can lead you to sources and you can take a look at it. The Institute for Local Government, which you can, Google, look at online, they have amazing materials. I find them to be very readable. Often they have hypotheticals in a question and answer format. And I think they've taken some very difficult concepts and they have explained them in ways that are really easy for me to understand. And so I would encourage you to look at them. So we're headed into the last portion, subsection D, on the open session for municipal liability. We're going to go into closed session and actually talk about the cases. But what I wanted to tell you and also members of the public are a few things about municipal liability. So we all know that in California, a city can be sued for money damages. But there's a law called the California Tort Claims Act, the government tort claims laws. The claims have to meet the requirements of the Tort Claim Act. And in California, if a person wants to sue a city for money, they have to file a claim. The city is supposed to review that claim carefully. If the city decides to reject that claim, then and only then can the individual pursue a lawsuit against the city. If they fail to file the claim, they fail to give the city the opportunity to take a look at their allegations, sometimes we are able to have that action dismissed. Although I would say these days the courts have been pretty lenient about allowing people to go back and remedy the filing of a claim. In our city in San Bernardino, the majority of claims against the city are for personal and property damages. This can occur either in trip and fall cases. It happens in many cities. Auto and pedestrian accidents, either maybe some of our employees might be involved. More often, it's just members of the public that are involved in accidents. And when there are significant injuries, and sadly, particularly when there are fatalities, the city ends up getting a claim. They try to base these claims on dangerous conditions of property. So they might say that the city knew about the dangerous condition and did nothing to remedy it. Sometimes we see claims from the everyday activities of our police officers. Again, sadly, when those activities end up in significant injuries or even in fatalities, we see pretty significant claims against the city. The city also faces lawsuits from employees. We face lawsuits from applicants who apply for permits, and we face lawsuits from people who are doing business with the city. I'm a believer that we can reduce our liability. We can reduce liability by fixing things that need to be fixed, whether those are potholes or cracks in sidewalks. We can reduce liability by knowing where we might have conditions of property that need to be fixed. And we can reduce liability, particularly in the area of the employees and applicants and permits, if we follow rules and procedures. One thing I want to remind the council is, I want to go back to this concept of your fiduciary duty. You as a council member at times may be very frustrated as your constituents are with the situation. You may see something that you want to see fixed immediately. And you have every right, and you should, and I encourage you to bring that to the attention of staff, whether through the city manager, through Public Works, to remedy that. But there's also a careful balance between discussing liability in public or, being the one to say, that road has been dangerous for 30 years and no one's done anything to fix it. And I can't tell you what to do in those situations, because I think sometimes elected officials get so angry and frustrated, they feel that that's the only way to get attention. But I think there's a balance there for you having to ask yourself, what's in the best interest of this city that you serve. So I would just say to you that if you see conditions out there that you believe are dangerous, that need to be remedied, bring them to the attention of the city manager. Give staff an opportunity to fix them to reduce liability. But the worst thing you could do is discuss them in public in a way that we get a claim, and then you're the witness and you're the one they call to testify against the very entity that you serve. So that's all I have for the open session right now. I'm happy to take questions. If there are not any questions, then we'll move into closed session. I know we have to sign out to do that, but we're prepared to do that. So Mayor Pro Tem, I'll hand it back to you.
Thank you, Ms. City Attorney. Not sure if anybody has any last questions before we adjourn the open session. I'm looking. Okay, I see no questions. So with that, we're going to adjourn the special meeting and resume into closed session. Thank you.
Okay.